welcome to the 258th session of Legal Empowerment through Interaction lecture series. As the journey continues, we have been discussing and deliberating on different points. Today, we thought of zeroing down on a particular aspect of registration, admission of document, and things related to that. Today, we are privileged that we have Justice Hariprasad sir, who will be addressing on the topic that is effect of non-registration of compulsorily registrable documents. There is a lot of confusion going on, and I think by the end of today's session, we'll have a quietus of the issue in the sense like we'll have a fair idea of what exactly are the nuances of registration, the compulsory nature of which, and how the evidentiary value of a document would be impacted by non-registration if it is otherwise compulsorily registrable. We are indeed thankful that we have Justice Ramkumar sir, Justice Ramakrishnan sir, and all of you wonderful participants, and especially the students of Bhavan's Law College who has joined today for this session. I'm sure that we all will leave this platform as a Saturday evening well spent. So this being a thoroughly informal platform, we don't waste time on anything. We'll directly go over to the speaker. Justice Hariprasad sir, please.
Thank you, Shyam. Very good evening, sir. Ramkumar sir, Ramakrishnan sir, Rao sir, and all my friends, dear students. Today we are going to discuss a subject. Probably one way it is very easy to present. The other way it's slightly complicated if you view from a different different perspectives. Anyway, I shall try to be as brief as possible, and I shall try to be as clear as possible. Now, the topic today is the effect of non-registration of documents which are compulsorily registrable under the provisions of the Registration Act. Now, to begin with, I may tell you that the purpose of registration is to have a certainty in respect of a transaction which is said to have happened between parties. Now, see, if it is everything is oral, probably after 10 years or 15 years or 100 years, it may not be possible to find out what happened at that time. You have to depend on conjectures and surmises. So everything has to be reduced. And if it is reduced, it should be kept on record. That is the purpose of Registration Act. Because if you glance through the history of the Registration Acts, various Registration Acts that prevailed in India, starting from 1864, then it came 1886 Act, then 1877 Act, and finally we are on 1908 Act. So there are at least 4 enactments, including the present one, relating to the law of registration in India. And I may also bring one fact to your attention, that the Registration Act and CPC are of the same year, as in the case of 1908 Limitation Act was also there. So all these enactments are part of one scheme formulated in 1908 in respect of properties and in respect of legal rights over immobile properties. So this is the background in which we have to understand the Registration Act. Then we find a lot of mentioning of documents, in various sections in the Registration Act. We will find the expression documents have been referred to in plenty. But the word document has not been defined in the Registration Act. To understand the word document, you will have to go into the Indian Evidence Act. Because Indian Evidence Act was of the year 1872. And of course, the Registration Act, when it was enacted in 1908, the legislature was aware of the fact that Evidence Act is in force. Then, so document is defined in Section 3 of the Evidence Act. Document means any matter expressed or described upon any substance by means of letters, figures, or marks, or by more than one of those means intended to be used or which may be used for the purpose of recording that matter. So this is the definition of document. But when we consider the scope of Registration Act, we will have to confine the expression documents to the documents written on paper and then registered. Because of course now the electronic system is also in vogue, but when it was enacted, it was only in respect of paper documents. Because if you go to the illustrations, you will find in the Evidence Act, an inscription on a metal plate or stone is a document. it can't be registered under the Registration Act. So there is one portion of the document defined in the Evidence Act is the subject matter of Registration Act. Now, coming to that. Now we will straight away go to section 17 before going to section 49, which is the crucial provision. We will understand what is the scope of section 17. Section 17 speaks about the documents of which registration is compulsory. That is what section 17 says. Yes, 17. The following documents shall be registered if the property to which they relate is situated in a district in which, and if they have been executed on or after the date on which the Act in 1864, 1866, or 1877, or this Act comes into force. So all the prior three acts have been mentioned in this section, and this becomes compulsory registrable in respect of the documents enumerated in section 17. And one important aspect is that 17(1)(a) says that instruments of gift of immovable property. So whatever be the value of the property involved in the gift, it becomes a compulsorily registrable document if it pertains to immovable property. Any gift pertaining to immovable property, irrespective of its value, pecuniary value, is compulsorily registrable. And then B, other non-testamentary instruments, that is in documents inter vivos, which purport or operate to create, declare, assign, limit, or extinguish, whether in present or in future, any right, title, or interest, whether vested or contingent, of the value of rupees 100 and upwards to or in immovable property. So there is a value fixed in 17B, which is 100 rupees, and any document, any non-testamentary document purporting to create, declare, assign, limit, or extinguish any right, title, or interest in respect of immovable property has to be registered. That is what 17B says. Then C says non-testamentary instruments which acknowledge the receipt of payment of any consideration on account of the creation, declaration, assignment, limitation, extinction, etc., etc. For example, registered this release of a mortgage, this thing. So this anyway, B is the normally the provision which comes into play normally is 17(1)(b). So section 17, the gist of section 17 is that the documents mentioned therein of a particular value, in the case of non-testamentary documents other than gift, will have to be registered compulsorily. Gift of any value must be registered. So this is the substance of section 17. Then one provision was later amended, 17(1)(a), that was added in the year 2001 with effect from 24/9/2001. That provision says, now I'll just take you through the provisions, relevant provisions first, and then I'll revert back to the subject. Section 17(1)(a) says, the documents containing contracts to transfer for consideration any immovable property for the purpose of section 53 capital A of the Transfer of Property Act 1882 shall be registered if they have been executed on or after the commencement of the registration and other related laws Amendment Act 2001, and such documents are not registered on or after such commencement, then they shall have no effect for the purpose of the section 53A. So the section 17(1)(a) was introduced in the statute book to make it clear that any unregistered document or contract containing contracts to transfer for consideration any immovable property will have no effect for claiming section 53A benefit under section 53 of the TP Act. And if you want to rely on that, if you want to see, for example, 53A, there are a lot of benefits. We'll go to that later. If you want to get the benefit under 53A TP Act, the contract in respect of immovable property for sale of property, whatever it is, it has to be registered. That is the scope of amendment of 17(1)(a). Then comes, then of course the other provision I am not reading. This is a very long section. Please go through that. Then of course, before going to the other aspects in the Evidence Act, I'll take you to Section 49, which is the cardinal provision for our purpose. Section 49 of the Registration Act reads like this. No document required by Section 17 or by any provision of the Transfer of Property Act to be registered shall affect any immovable property comprised therein, or confer any power to adopt, or be received as evidence of any transaction affecting such property or conferring such power. So there are three limbs. If a document which is compulsorily registrable under Section 17, and if it is not registered, then it shall not affect any immovable property comprised therein. In any manner, it doesn't affect. So title doesn't pass, no benefit can be claimed. That is very clear, explicitly clear. Then B, confer any power to adopt. That is in the case of adoption, deed of adoption and etc. Other thing. Or C, be received as evidence of any transaction affecting such property or conferring such power unless it has been registered. So as evidence we will consider later. That is a crucial expression. That is the crux of the issue here. So I'll give stress to that at later point of time. Then comes the proviso. Provided that an unregistered document affecting immovable property and required by this Act or the Transfer of Property Act to be registered may be received as evidence of a contract in a suit for specific performance under Chapter 2 of the Specific Relief Act 1877, at present 1963 Act, or as evidence of any collateral transaction not required to be effected by registered instrument. So the proviso makes it clear that even though the document which is of a compulsorily registrable nature as prescribed by Section 17, if it remains an unregistered document, it may be used in a suit for specific performance for enforcing a contract or as evidence of any collateral transaction not required to be effected by a registered instrument. So, two purposes by virtue of operation of this proviso, whatever contained in Section 49 is subject to exception that an unregistered contract in respect of immovable property can be specifically enforced under the provisions of the Specific Relief Act 63 Act, or as evidence of any collateral transaction not required to be effected by a registered instrument. Except for these two purposes mentioned in the proviso, a document which ought to have been registered under Section 17 cannot be used. That is the plain wording of Section 49. Now we will come to the question. Now the point to be decided is to what extent you can use this document, which is compulsorily registrable under the section, under the provisions of Section 17. And is there any conflict between Section 17(1)(a) and proviso to Section this 49? And whether, I think if I remember correctly, the question posed by Mr. Shyam is whether a contract purported to have executed in respect of an agreement to sale can be specifically enforced in the light of this 1A. That appears to be the question that is posed. I'll answer that question. Before that, I just wanted to tell you a special feature prevailing in Kerala. I do not know whether it is available in other states because it's a state amendment. What happened is that Shyam, you have that Act 31 of 17 with you? Sorry, 31 of 13, Kerala Amendment Act. Okay, there is an, I'll read it out later. There is a Kerala amendment to the Registration Act effected by Act 31 of, correct, that's it. Act 31 of 2013. No, amendment 2012. No. Follow, correct. Act 31 of 13. Will you please?
2012 will anu, but it is Act 31 of 2013.
13 are there. Please, will you please, what do you call it? This bring 17 slightly above, slightly.
Amendment Section 17.
Amendment of Section 17. Can you please
scroll up?
it? Scroll up, please. Yes, correct. In section 17, it says like this. In section 17 of the Registration Act 1908, that is Central Act, in subsection 1, after clause E, the following clauses shall be inserted. And you will find F2, F2.
F and G.
No, there are up to F2K. You will find F2K provisions newly added. No, we are only concerned with F.
We find only F and G, did not.
G deals with power of attorney.
Yes.
Of course. You are correct.
After G.
Yes, correct. Instruments purporting or operating to effect a contract for the sale of immovable property of the value of 100 rupees and upwards. G, power of attorney creating any power or right of management, administration, development, transfer, or any other transaction relating to immovable property of the value of 100 rupees and upwards, other than those executed in favor of father, mother, wife, etc., etc. I think, Justice Ramkumar sir, I think G is not the point of dispute here. F appears to be the crucial area where the doubt arises. Instruments purporting or operating to effect a contract for the sale of immovable property or the value of 100 rupees and upwards, because it appears to be in conflict with the proviso to section 49. That is the confusion.
But 17.1a, in accord with 17.1a, is it not? 1a.
Pardon?
It is in accord with 17.1a, is it not?
No, actually 17.1a simply says that any contract which is not registered under the provisions of any contract to assign land which is not registered under the provisions of the Registration Act cannot be used for part performance under section 53A. That is the only scope of 1A, 17.1a. Whereas this 17.1F added by the Kerala amendment,
it's made it compulsory.
Compulsorily registrable.
It says that any specific contract for agreement, any agreement for sale of property has to be registered. So that actually directly hits the one portion of the proviso to section 49.
If it is not registered, probably it cannot be used for that purpose also.
I'll answer. That is the crucial question. So these are the statutory provisions over which we are now discussing. These are the central points where the attention has to be drawn. Now, yes. So according to, in my view, the present situation in Kerala, it may be different from other states. Of course, if there is no provision parallel or akin to section 17.1F, the proviso to section 49 will have its full operation elsewhere, but not in Kerala. In Kerala, you have to read section 17.1F affecting or eclipsing that portion of the proviso which says in a contract, received as evidence of a contract in a suit for specific performance under Chapter 2 of the Specific Relief Act. So, provided that an unregistered document affecting immovable property and required by this Act or the Transfer Property Act to be registered may be received as evidence of a contract in a suit for specific performance under Chapter 2 of the Specific Relief Act 1877, presently 1963. Now, this has to be read subject to 17.1F.
Okay. Has Kerala amendment received the assent of the President?
Yes, it has received the amendment. It is in the concurrent list. So in Kerala, the situation is different. Proviso first part has no application in Kerala.
If it has received the assent of the President, then yes, it will prevail.
It will prevail. Because Central Act stands modified to that extent. So proviso first part is now covered by 17.1F. But it can be used or as evidence of any collateral transaction not required to be affected by the registered instrument. That part remains. Proviso, there are two parts. One is relating to the use of such an unregistered contract for assigning property in a suit for specific performance. That is the first part of the proviso. There are two limbs to that proviso. First limb deals with the usability or the utilization possible of such a contract in a suit for specific performance, which is now eclipsed in Kerala by 17.1F. But in other states, if there are no such provision parallel to 17.1F, still this can be used in a suit for specific performance even an unregistered document can be used. Then in Kerala, as in the case of other states, the second part of the proviso to section 49 is still applicable, which says received as evidence of any collateral transaction not required to be effected by registered instrument. So this is the legal impact of these provisions. So we have seen section 17 dealing with compulsorily registrable documents, 17(1)(a) saying that a contract for sale, if not registered, it can't be used to claim the benefit under section 53A of the TP Act. And now by introducing, the Kerala legislature introduced 17(1)(f) in the Act, restricting the use of unregistered agreement to assign, limiting or rather saying that the indirectly saying that the first part of this proviso to section 49 cannot be worked in Kerala. Then the collateral issue that is left open. Collateral purpose is still available because it is not covered by 17(1)(f). I think I am making myself clear. If there is any ambiguity, I shall repeat it again. Shyam, I think the point is clear. That is what I'm trying to...
I mean, the doubt was because we didn't notice that 2013 amendment, so a lot of confusion was there because we thought that we are doing violence to the express terms of the statute.
Okay, now I'll go to one of my decisions. Probably that is the root cause of this doubt.
Absolutely.
I'll clarify that. That was a case. That is 2017.
You are the problem maker.
2017 3 KHC 836. That is Ignatius versus Dominic. 2017 3 KHC 836. I think for the purpose of Mr. Rao and other participants outside, probably you can have this Manupatra citation also. Shyam, if you are able to give them, please.
It is there. It is there.
Is AR there?
There is KHC, KLJ, and ILR and Manu. I think it's on screen. Can you see
ILR
that?
may be accessible. Is not.
Is it visible?
Yes, it is visible. Yes. No, the question there.
ILR is there.
ILR 2017 for Kerala 622.
622, yes.
Okay. No, actually the question posed in that case was a suit for the specific performance was filed and it was decreed ex parte. And thereafter, by invoking section 28(3) of the Specific Relief Act, the plaintiff filed an application for getting a sale deed executed through court. Since this was actually a 227 petition filed before the High Court, OPC, the petitioner herein, that is the defendant in the suit, did not obey the decree. So the court executed the document under section 28. Now that order is under challenge. There are a lot of questions raised because they say that a lot of title issues, so many issues were raised, but it was not contended, it was not contested at the trial stage. Now the ultimate points raised before the High Court is this. Petitioner's counsel vehemently contended that Exhibit P2 suit for specific performance of contract, perpetual injunction and other release should have been held not maintainable in law. Exhibit P3 judgment is per se unsustainable. The execution proceedings therefore is also illegal. Challenge in this proceedings is against Exhibit P6 order passed by the trial court on an application under section 28 of the Specific Relief Act, requesting the court to execute the document in favor of the respondent and also put him in possession of the property. Then, of course, the facts goes on like this. Then the section 17(1)(a) play was considered. It was just read one small portion of it. Section 17(1)(a) was introduced by an amendment which came into force with effect from 29/4/2001. Exhibit P1 agreement came into existence almost 10 months after introducing section 17(1)(a) to the statute book. The section mentions about need of registration of a document for the purpose of claiming benefit under section 53 of the TP Act. Then consequential amendment to section 53 capital of the TP Act was also made because in TP Act, originally as it existed in the TP Act, the words originally existed in the 4th paragraph that the contract, though required to be registered, has not been registered. it can be used for part performance was the original wording. So this by in what you call consequent to the amendment to Registration Act by incorporating 17(1)(a), this wording, this expression, contract though required to be registered, has not been used in TP Act, has been deleted. That expression has been deleted. So it's now the 53. If you read 53(a), it will be clear that it can be used only when it is registered, because it is now connected with 17(1)(a). So the expression originally occurred in the section 53(a), that the contract though required to be registered has not been registered. Those words are deleted. That is the amendment made in 53(a) to make it in consonance with the 17(1)(a). Then that portion that has been discussed. Then another point argued is as evidence. I told you earlier that as evidence and in evidence there is a difference, because as evidence means if you read the sections 60, 61 and 62 of the Evidence Act coupled with some provisions in the CPC, it will be clear. Section 61. Section 61 of the Evidence Act says about primary evidence. Primary evidence means the document itself produced for the purpose of examination, produced for the inspection of the court. That is 61. So as evidence means if you produce a sale deed, unregistered sale deed, or any unregistered mortgage deed, that itself is the proof of a transaction. That is the spirit of section 61. 62 speaks about this primary evidence. Primary evidence means the document itself produced for the inspection. Then of course, we are aware that 9192 bar, proving the terms of a document under the 9192. And if you go to CPC, the provisions I have referred to in my judgment, that is Order 6, Rule 2, it appears.
What are to be pleaded?
Order 6, Rule 2 says that the pleadings must be as brief as possible. And when you produce a document along with the pleadings, it becomes part of the pleadings. So it need not be pleaded in detail. That is the spirit of the CPC. I'm just telling you the provisions there. So what is evident from these provisions, reading the Evidence Act, the CPC and the provisions of the Registration Act together, what we understand is that when a document itself is the transaction, and if that document is not legally recognizable on account of the fact of non-registration, then it can't be received as evidence of the transaction. It doesn't show that transaction. It shows something, but not the transaction, something inferior to that. There the importance of collateral transaction comes into play. Collateral means, see, what is the purpose of executing a document? That is meant to convey something to someone, or rather, to transfer title, to grant something. No, that is the purpose of creating a document. If that document, due to non-registration, if that cannot be used for that purpose, it can be used for some inferior purpose. Because the wording in section 17, what we have seen, 1 minute, I will revert to section 17. 17(1)(b) says, other non-testamentary instruments which purport or operate to create, declare, assign, limit, or extinguish, whether in present or in future, any right, title, or interest, whether vested or contingent, of the value of 100 rupees and upwards, etc., in a movable property. So, the document is purported to operate, create, declare, assign, limit, or extinguish. So these are the fundamental purposes of executing a document. If that, by virtue of section 49, if that cannot be used for these fundamental purposes, if it can be used for some inferior purposes, it is permitted by proviso. Then what is collateral purpose? A collateral purpose is a purpose which is not the substantive purpose, which is something other than that. For example, a person says that I am a lessee, a lease deed executed for 2 years. Naturally, going by section 17, it has to be registered. Any lease beyond 1 year has to be registered. But this document is not registered. he has a lease deed prescribing a period of 2 years. So he can't produce this document and prove that there is a lease. But he can prove the factum of lease through other means, and to explain the way his possession, that document can be relied on. That is called collateral purposes. How you happen to be in possession? You say that you are a lessee. Handing over a possession is an important aspect in a lease, transaction of lease. Then how did you come into possession of the property? Such a question is raised. He can explain the possession by saying that, look here, there is a lease deed which ought to have been registered, but I am having a lease deed not registered. I have lease. And if you are able to prove lease by other means, well and good. If you are not able to prove lease by other means, you lost. That's a different issue. But if you have other reasons to prove lease, and if you want to have an additional factor to establish your lease, like in possession or paying rent, why do you pay rent? Because I pay rent, I am a lessee by virtue of this document. Though it is not registered, I still remain to be a lessee. So that is the purpose. The purpose is very clear, which is not the substantive purpose, which is not the main purpose. For any purpose, it can be used. That is what section 49 says. So this is the idea behind these provisions. Now, I'll just, before going further, I'll just refer you to one decision recently by the Supreme Court, this delivered through Justice K.M. Joseph.
A settlement.
Will you please, Shyam, will you please share that decision in the screen?
That is, I think, 2021 KHC 6567.
Yes, it's not that. 21 KHC 6567. And I think Shyam is having that copy. You can share it in the screen. Yes, that's it. This decision, the Supreme Court was called upon to consider the reliability or rather acceptability of a family settlement. And in the course of discussion, there are a lot of what you call these points raised regarding how a family settlement has to be raised, because fundamentally family settlement is a settlement of disputes in presente and a possible dispute, future dispute. It can be between family members or anybody likely to have an interest in the family, because it is so wide a term, so that all possible disputes must be settled through a family settlement. That is there are a lot of Privy Council decisions on the point regarding family settlements. It is in respect of persons having no right, in respect of family members having no right, probably this may operate as gift. There's a lot of legal propositions emanating from these type of litigations. And finally, the Supreme Court. Shyam, will you please take me to paragraph 26?
Yes, Professor.
Yes. Yeah, 1 minute. 25, madam. Please take me to 25. Yes, section 40, correct. Section 49C of Registration Act prohibits the admitting of compulsorily registrable documents which are unregistered as evidence of any transaction affecting immovable property unless it has been registered. In the very same judgment, we notice the following. That's quotation from my judgment. The other consequence of non-registration is to prohibit. 1 minute, please. Other consequence of non-registration is to prohibit the document from being received not in evidence but as evidence of any transaction affecting. That is the Madras view. And then please slightly move forward. Next page, please. Next page. Then in other words, the prohibition is to prevent a person from establishing by the use of the document in evidence a transaction affecting immovable property. A person should not be permitted to establish indirectly by use of the document what he is prevented from doing directly under the clause A. Then the proviso carves out two exceptions. We are only concerned in this case with one of them, and that is contained in the last limb of the proviso. The unregistered document can be used as evidence of any collateral transaction. This is, however, subject to the condition that the said collateral transaction should not itself be one which must be effected by a registered document. it is this expression contained in the proviso which leads us to ask the question as to what would constitute a collateral transaction. If it were collateral transaction, then an unregistered document can indeed be used as evidence to prove the same. Would possession being enjoyed or the nature of possession on the basis of the unregistered document be a transaction, and further it would be a collateral transaction? We propose this question as the contention of the appellant is, etc. Then going to that facts. So the principle stated in this decision, the latest Supreme Court decision, is also in tune with this Ignatius. And of course, there cannot be a different view because this is all long settled principle. Right from Privy Council, there is no change in the provision. Everybody interpreted in the same manner. So what is meant by collateral transaction, as I told you earlier, it can be explaining away the possession by a lessee. Now, suppose a suit for ejectment is filed. Plaintiff files a suit against the defendant saying that he is a trespasser and he occupies the land unauthorizedly, and the suit is within 12 years, ejectment suit, right? Royal ejection suit. Then the defendant says that, no, I am not a trespasser, I am a lessee. I have been given lease for 3 years, but there is no registered document in my favor. This is the document executed. So he can say that he can produce this document not for proving lease, but for explaining away his possession. Now, these purposes are called collateral purposes, which is permissible under the second part of proviso to section 49, which remains unaffected by introduction of section 17(1)(f) in the Kerala state. So, suppose in Bombay or in any other place or in any other state, if a provision akin to section 17(1)(f), which exists in Kerala, saying that every contract for assigning land must be registered, then still the entire proviso is workable outside Kerala. But by virtue of this 17(1)(f), first limb of 49 proviso becomes unworkable, because in a suit for special performance, you can produce this document, this contract, unregistered contract, and say that this has to be received as evidence of a contract. That is the distinction now. I hope I am clear on this subject. Now, this is in my case, probably the question was different. In my case, because I have explained away by saying that the contract in that Ignatius case was executed in the year 2002. 2001, immediately after the amendment in 2001, which introduced 17(1)(a). 17(1)(a)'s scope is only to restrict the right of a person who is having an unregistered document to claim part performance under section 53(a). Section 17(1)(a) did not have any inroad or impact on the proviso to section 49. It has not affected proviso to section 49. But 17(1)(f) introduced in Kerala, requiring all the contracts relating to immutable property, it has to be registered mandatorily. It gives a clear hit on the first part of the first proviso to section 49, and a suit in respect of an unregistered contract is not maintainable in Kerala now. If such a provision is not available outside Kerala, it can still, the proviso in its full vigor applies. That is the point. So that is the whole thing about this. And as I told you earlier, substantive purpose of executing a document is to create limit, these are the expressions, to create, declare, assign, limit, or extinguish. No, these are the substantive purposes of executing a document covered by section 17. Collateral purpose referred to in the proviso to section 49 is any purpose other than this thing mentioned in section 17. This is the principle. And the latest Supreme Court, and there are other decisions also of the Supreme Court, Shyam, probably that 2008 or the other decision is there, Supreme Court. But that's a, you send me a decision by Justice
Ravindran, Justice Ravindran.
Ravindran's decision, yes. Anyway, that's actually a different issue.
No, even in the case of a lease also, in that case, it said that possession also cannot be possible or something like that, it appears. If you are tracing to the...
You can't prove that you are a lessee. You can only say that I am in possession.
In possession.
I am a lessee. by virtue of a document, please look into this unregistered document to consider my possession. But as a lessee, you don't have a full status by this document.
Whether you are a trespasser or a person in possession by virtue of...
You can explain away your nature of possession. That's all. So this is the sum and substance of this section 49 principle. I may just sum up by saying that these are the and of course one provision Justice Loh that actually Kala Devi, yes, that is reported. That is reported in SEC. I don't have the citation with me. Yes. So and of course the 91 and 92 comes into play because you have to adduce oral evidence in the case in case the document is not admissible as evidence. Then of course this will be subject to 91 and 92 again. But of course that's not our point of discussion. But then I just remind you of those provisions. That's all. So Shyam, I think this is the point that I wanted to drive at.
Yes, sir, definitely. I think we'll just go on to that with, we'll start with Kodandaram, sir. Justice Kodandaram, sir, please.
Sir, my apologies, I joined a bit late. Today there was some...
Namaste, sir. Namaste.
Chief Justice of India was here. There's a lot of arbitration, new arbitration, international arbitration center foundation has been laid, and some curtain raiser has been done and all by the Chief Justice of India. So we just returned. The subject being is, but at the same time, sir, I always get confusion with regard to this collateral purpose.
Exactly.
It's each time, we keep variegating the judgment this way and that way. It all depends on the person who is judging at what point of time and in relation to what kind of the facts which appeal to the judge.
Objective justice.
Yeah, subjective justice. But one
is objective,
which I'm glad with today is that clarification in the section what has been specifically stated shall be taken as substantive rights for which purpose which are required to be registered. Other than those things can be fall into two baskets.
Yes. No, sir, it can be said.
Some element of guidance on that aspect has come.
Sir, I think it can be simply, for the sake of students also listening this, I can tell them for easy understanding. No, a document is executed with a purpose. Either to, what you call, section 17 says declare, assign, limit, extinguish, so many purposes. Declare, assign, limit or extinguish, create, etc. So if a document is executed for these purposes, it cannot be used for all these purposes. It can be used for any purpose inferior to these purposes.
Any purpose other than the specified
other than these purposes.
Collateral. We can
correct.
That way.
That is correct. That is the best way of expressing it.
Thank you, sir. That was a clarification which I...
Thank you. Thank you, sir.
Thank you, Justice Kodandaram, sir. Justice Ramkumar, sir, your comments.
I am getting re-civilized. In fact, I am still lingering under a lot of doubts. I also was under the impression that collateral purpose means supposing there is an invalid lease, unregistered lease, then the document, it can be looked into for the limited purpose of finding out the status of or the character in which the so-called lessee purported to enter the property.
Yes.
That was my understanding also. But then some confusion is injected by, there is a 3-judge ruling, 3 judges bench decision of the Supreme Court in Food Corporation of India versus VK Traders, AR 2020, Supreme Court 2266, 3 judges, mind you. Unregistered lease deeds in question did not convey any right to the purported lessee as they did not satisfy the statutory requirements of Section 17(1)(d) of the Registration Act 1908. These lease deeds cannot be accepted as valid transfer of possessory rights. Even transfer of possessory rights, they cannot be looked into. What the Supreme Court says. This is confusing for me.
No, sir. I think I can support that decision by saying, because lessee. So if you read 1 minute, I'll take TP Act, Section 108 of the TP Act.
Yes.
I'll just take that 1 minute.
That is for lessee's condition. Covenant.
No, that is the rights and liabilities of lessees.
Of the lessees and lessor.
Lessees and lessor. The
Yes.
lessee has a right to demand possession. Okay. 17(1)(b). The lessor is bound on the request of the lessor is bound on the lessee's request to put him in possession of the property. So that is what 108(b) says.
Yes.
So suppose the person who is holding an unregistered lease deed says that there is a lease created between us and I am put in possession in accordance with the terms of the lease deed or pursuant to the execution of the lease deed. That question may not be looked into because it is what you call limiting, etc., in 17. So for that purpose, you can't look into that. No, suppose no. See, there need not be a lease. There need not be a document creating lease if it is less than 1 year. No doubt.
Yes.
If it is above 1 year, it is mandatorily registrable. Suppose he says that say 3 years unregistered document, he can't have that contention.
Yes.
Suppose he sets up a case that it was only for 11 months. Take a case, example, 11 months, I am in possession. And if there is a dispute regarding the nature and character of his possession, he says that this was a document executed, but since this is not registered, I am put in possession only for 11 months. And this is my answer for saying that I am not a lessee or I am a trespasser. To that extent, he can use it.
But he is a lessee. A lease for 11 months, he is a lessee.
He is a lessee. And if the other person says that you are not a lessee, he can show this document to show that he is a lessee. He can produce this, correct?
No, it is not compulsorily registered.
Not sir. If you read section 107, that will make it clear, because if it is an oral lease, it is all right.
Yes.
If it is a document reduced in writing by virtue of which you have been put in possession as a created a lease, then even if it is 11 months, it must be registered by a registered document. They say, if you see 107, it will make it clear.
Beyond 1 year is
no. Even beyond, nothing.
107 is very clear. Beyond 1 year,
it has to be registered, no doubt. Even section 17 says so. Section 17 of the Registration Act says.
107 also. DPA 107 also. Beyond 1 year, compulsorily registered. That is why we execute documents less than 11 months.
11 months.
No, sir. If I understood correctly, 106, 107, if you go join of those things, it will be seen that if it is reduced in writing, it must be by a registered document.
No, I don't think.
Remember, I don't have the book here.
Ramesh, I think that is not the position. A lease of immovable property from year to year, or for any term exceeding 1 year, or reserving a yearly rent.
Exceeding 1 year.
Only by a registered document.
Yes.
So you can't, or a transaction can't be
exceeding
registered.
1 year.
Exceeding 1 year, it's only by a registered document means it must be in the form of a document. You can't have an oral transaction. No doubt about it.
All other leases of immovable property may be made either by a registered document or by an oral agreement accompanied by delivery of property.
Correct. No, any lease in respect of immovable property exceeding 1 year has to be reduced to the form of a document, and it is compulsorily registrable.
So there are two requirements. One is to reducing into writing, another is to registration.
Correct. Both have to be there. And sir, in Justice Ramkumar cited decision, I have not read it, but what I understand is that he can't claim possession by virtue of the lease deed, unregistered lease deed.
So supposing the document recites that you are put in possession under this.
He can't rely on that. He can't
that possession. That recital regarding possession also cannot be relied on. I say this thing that what is that last part of 49C.
Collateral purpose.
Collateral purpose.
No, probably in that case, I also not read it, but probably in that case, he may be.
Somayajilu in
Andhra
2019 has taken the view that even for the factum of putting in possession cannot be treated as a collateral purpose if you cannot look into the document.
Correct. No, that is what I drew your attention to.
That
section
108. My impression was also that even though the document is inadmissible in evidence, you can look into the nature of possession, etc. But now the position seems to be, even Supreme Court says, even the possessory right Even the
I have not read
possessory
the
right
lessee.
Not, sir. I don't think that way. What was sent, probably in that case, on the basis of that possession, he may be claiming some right arising of that possession, arising out of that possession.
As a lessee.
As a lessee, as arising out of that possession. Suppose, for example, I am then put in possession with the document by which I am entitled to collect rent, or I am entitled to do something. But in such cases, probably relying on that document as a document of creation of a right, you cannot claim it. Probably that may be the facts.
I read that decision. I don't want to make a comment.
No, I do not know, because I think that there may be.
Supposing the lease is invalid, the lessee cannot prescribe an adverse title against
that
the lessor.
cannot be. That cannot be possible. It's only a permissive possession.
He can prescribe the title of a lessee.
Yes.
He can prescribe the limited right of a lessee against the lessor if the lease is invalid.
Correct.
Yes, Justice Ramkumar sir, can you just share that citation again for the benefit of viewers?
2020, AR 2020, Supreme Court 2266. 3 judges. In fact, I have not read the entire judgment, but this is the observation. These lease deeds cannot be accepted as a valid transfer of possessory rights. Until then, I was under the impression that even regarding question of possession, you can look into the document, or even if the document is inadmissible, the nature of possession can be looked into.
No,
that is my understanding.
Ramkumar sir, shall I try to explain it once more in a different way?
Yes.
No, in every lease, in respect of immobile property, right to get possession is innate in every lessee. You can demand possession, no doubt.
Even lessee, not only lessee, even vendee, whoever it be.
See, we are only talking about lease now. For the time being, we are discussing lease in the context of this the decision that you have referred to.
Yes.
A lessee has a right under Section 108B to demand possession of demand from the lessor possession of the property.
Yes.
Now, suppose he says that pursuant to this unregistered document I am put in possession, he is debarred from saying by virtue of Section 49. So he can't say that. Suppose a lease is created, I am put in possession and a document is executed, then he can explain away his possession by virtue of this unregistered lease deed. But if he says that I derived possession through this document, he can't do that.
Yes.
That is the simple way of looking at it.
Deholds the document. You mean deholds the document?
Deholds the document. Suppose there is a case that, see, in the case of a vendee, we can visualize a situation. In the case of a vendee, suppose there is an agreement to sell property. Even before execution of the document, probably the purchaser will be put in possession of the property. And suppose the sale deed is not registered. He is in possession. He came into possession even before the execution of the document. That's possible. If that case, he can explain his possession.
Is it not? 53A?
53A. 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 He can do that. But this can't be looked into. This document can't be looked into to read. There must be a clause saying that a possession has been given to you by pursuant to this document or in accordance with the terms of the document. That can't be relied on by virtue of Section 49.
How will you explain your possession otherwise?
That is difficult. No, that exactly the legislature wanted to have a predicament to such persons. It is not it is a hurdle created for them. No, the scheme of the act is that compulsory registrable documents must be registered. If it is not done, you are met with a lot of penal consequence. This is one of the penal consequences. These contentions are very limited. If you are able to explain this thing in a different way, in a lawfully acceptable manner, you can use it only to that limited extent. No, suppose, sir, I'll just put the other way also. Suppose proviso to 49 was not there. Assume for a moment. Proviso to Section 49 was not there means completely you are out of this thing. You can't have anything because it doesn't affect any immobile property complies therein or confer any power to adopt or be received as evidence of any transaction. If the legislature has stopped without saying proviso or without providing proviso to Section 49, this is a very harsh provision. And proviso says that it can be unregistered contract can be used for special performance. And it can be used for collateral purposes. This comes into play only by virtue of a proviso. So proviso is a restriction of or rather in this case, this is a way out for the
enabling provision. Yes.
Enabling provision here. So enabling provision can't be wider than the original provision. It is only a small way out.
I will read that Justice Somayajilu's observation. AR 2019 Andhra Pradesh 93, year 2019, Andhra Pradesh 93. Defendant in a partition suit claiming title and possession on the basis of an unregistered sale deed executed in her favor by the plaintiff's predecessor. Sale deed cannot be received in evidence as it is not registered. It cannot also be received in evidence for a collateral purpose for the simple reason that possession given thereunder is not a collateral transaction.
Correct.
No, that is correct in that case.
That is independent. That is independent or divisible from the transfer recorded in the sale deed. Supposing the sale deed itself resides, you are put in possession. And can I rely on that recital in the sale deed as a collateral for the collateral purpose of proving my nature of possession?
Sir, shall I take you to one paragraph?
I am in doubt, but I don't want to assert any particular view.
Hariprasad sir, I have one more aspect there. Probably you need to interrelate both the things, and you should also see Order 13.
Order 13.
Order 13, Rule 3 and Rule 4.
Production of documents.
No, with regard to the documents which are inadmissible.
Correct.
And once they are inadmissible in evidence, then what to do with regard to this? Collateral purposes will come only in a limited, with respect to, as you pointed out, in which at what point of time, suppose if the document itself is inadmissible in evidence, it has to be eschewed from the record.
No, that is why Justice Ravi's judgment says, while admitting the document, there should be an endorsement that it is being admitted for the limited purpose of proving the collateral. In fact, that is what you said, that Kaladevi. Kaladevi, unregistered sale deed can be received in evidence after making an endorsement that it is received in evidence only as evidence of an oral agreement of sale under the proviso to section 14.
Correct.
Oral agreement of sale.
Limited purpose, you can look into that.
Even that cannot be done in Kerala. Oral agreement of sale.
Oral agreement can't be, because by virtue of after 2013, it is not possible in Kerala.
17(1)(f), yes.
No, you can't even file a suit on that.
Correct.
Which is barred.
Radhakrishna is lifted his hand. Radhakrishnan has questions. Radhakrishna Murthy has some question.
Radhakrishna Murthy.
Yeah. I said that hand, sir. I thought like let this basic discussion be over and then we'll go to Radhakrishna Murthy.
Is it in despair or?
No, it's not hands up. It's not.
Try to put question is only for the spectators, not for the judges who are deciding it. Probably that may be the. Because you are denying an opportunity to put the question.
We'll have your comments, sir, first, then we'll go to Radhakrishna Murthy, sir. Ramashan, sir.
No, it is always said, as Justice Kodanraman and Ramkumar were saying, in spite of several decisions of the Supreme Court, the question collateral purpose is being interpreted in a different way, causing confusion. That confusion is still there. That we cannot say that it is not there. But the way we suppose if there is a clarity in the decisions and for and because straitjacket formula has been given for only for what purposes and what is the nature you can done. I don't think that that confusion will be cleared. But as Hariprasad said, probably you may not be able to prove what was required to be proved under the or claim under the document, but something else which is not required to be proved, but for the purpose of establishing my character of possession. Say that making me as instead of making me as a trespasser, you can say that I am in possession because of the permission granted by virtue of such a document.
Ramashan, with your permission, one sentence I'll read from that Ignatius, which is quoting a Privy Council and all, because it's a settled proposition. I'm just read one sentence used by me. It has been judicially settled that collateral purpose is any purpose other than the substantive purpose, in order that a transaction may be considered a collateral transaction and therefore admitted in evidence. It must be A, independent, it must be A, B of, A means one, it must be one, B independent of or divisible from the transaction intended to be effected, which the law required registration. So it must be divisible and independent of the transaction intended by the document. One condition, or, and be the transaction not itself required to be effected by registered document. For example, a law does not insist that there should be a registered document. then it can be used. So that is these are the purposes of collateral. These are the meanings of collateral
I
transaction.
think that was explained in Kaladevi's case also, it appears. That was what was explained in the Kaladevi's case also.
Sir, I think
Justice Ravindran and Lodha.
Sir, I think what Hariprasad sir just read, I mean, the second part, that's my understanding from what you said, sir. That is, the collateral purpose which you intend to have should also by itself should not be necessitating a registered document. Then only that collateral purpose as such will come.
Correct. See, the collateral purpose that you are trying to prove shall never be a mandatorily registrable thing.
Correct. So the document which on the face of it evidences a transaction, that also should not be, even if it is to be registered and you are not registered, it could be used for a collateral purpose other than the principal thing for which it is. And that collateral purpose which you want to prove or establish using this document should by itself not be having the requirement of a registered document.
So can we not say that for passing of title, registration is necessary. For passing of possession, registration is not necessary. Therefore, that is a collateral purpose.
I think the fact that I'm in possession of a property by virtue of a lease, the lease or the hike in lease or periodic enhancement.
That's what I'm saying. For the purpose of transferring the leasehold right, for that compulsory registration is necessary.
At least to the limited extent that I'm not a trespasser.
Exactly. So I am creating a sublease. For example.
Yes, with permission.
With permission. It need not be registered, in fact. If it is go by the literal principle, it will not be registered. Even though because between the sublessee and the lessee, it will be a transfer and creating an interest in the property. But for the purpose of proving that I am a person in possession under him, I don't think that it is required.
Damkumar sir, I can explain your question in this way. Because suppose you say that...
My confusion is only from these decisions which say even possessory right cannot be.
See, possessory right as a lessee you can't claim.
Yes.
Because you say that there is a lease and I am in possession of the property as a lessee. Please don't look into this document. I am a lessee. But you don't have a case that you are a lessee by virtue of any other means. You don't have a case. You say that a document was executed. I became a lessee and I am in possession as a lessee. For all these things, lease becomes complete only when possession is handed over to you. So this is an integral part of the original transaction, creating, limiting, extinguishing, etc. So that, of course, it's a hit by section 49. Suppose you are in possession. You say that I am in possession, lawful possession. As you rightly pointed out, a person can even prescribe lease by adverse possession.
But only leasehold right. Supreme Court made it clear. You can prescribe only the lessee's right.
Lessee's right, not the lessor's right.
Exactly.
Because it is a derivative right. Lessee's right is a derivative right.
Though you are strictly not a tenant, not a lessee. Because lease is invalid.
If your lease is invalid, you don't claim any superior right. You are claiming only a derivative right, inferior right. So that you can prescribe. No, if you want to prescribe title of the lessor, you have to say that I am not a lessee, I am a trespasser. You have to say boldly say that I am a trespasser. Then only you can prescribe his absolute title.
Yes. There you will have to prove that on a particular day you asserted absolute title.
Correct.
And from that date onwards you can prescribe.
Right. You were originally a lessee. You disclaim the character as a lessee. You re-enter the property with a hostile animus. Keep it for 12 years. Then become an owner.
Exactly.
That is possible. And if you keep on discussing, we will reach nowhere.
Exactly.
That is correct.
I was wondering, all our young friends who are listening, oh my God, so much of complication.
No, say Justice.
Just register every document, registrable or not registrable. Just go, pay stamp duty and register it and finish it off, rather than getting into all these kind of
complications.
They will arise only when there is a litigation.
Justice Collateral, sir, we insisted for the students to be here because we just thought of giving them an exercise on this topic. Let them have their, all of us believe that law is settled. There is nothing more to be done. No, there is everything to be done. Let them do a research on this and let them come up with some new ideas.
We will provoke them to think.
That exactly is the very purpose of this platform.
Yes. Otherwise, generating discussion.
If you have to spoon feed them with everything, then it's not this platform. Why should we be here?
No,
One Kerala High Court judge, Justice Krishna Iyer, used to say, whenever you go for the academy, whether you are benefited or confused, when you are coming out, decide what you want, what you feel, what you understand on the basis of the decision.
If I am a young lawyer to start practice now, what I will do is, after listening to all that, you just go and register your document so that you will avoid all problems.
That is the best advice you can give to the client.
Sir, there is a financial amount, involvement that's coming in, stamp duty and registration. That might be a deterrent. We'll see what Dilip sir has got to say. Dilip.
Good evening, everyone.
Good evening, Dilip.
Sir, with due respect, I differ from the comments made regarding the effect of the amendment of Act of
Kerala Amendment
31 of 2013.
Yes, that only, according to me, that only lifts the necessity of an explanation to 1A, explanation 1A to section 17, because section 17 enumerates only five instances of non-registrable, compulsorily registrable documents. Yes. And sixth is, I'm sorry, only 3 is compulsorily registrable documents in section.
No, 17.1, there are A, B, C, D, E, 5 instances.
Yes. Then the amendment made in section 2, in 2013 takes
F by incorporating F and G.
Yes, up to K it has been incorporated.
There is an
the amending act does not show that.
One second.
And my book also does not show that. Law books.
The amendment has brought an amendment to clause D also of section 17, where there was lease of immovable property from year to year or any term exceeding 1 year or reserving a yearly rent was also amended as a lease deed for any term.
All right. Anyway, see, that was not our point of discussion. Actually, we were riveted on the exclusive performance.
I'm coming to that.
No. There is some purpose for that, because if it is possession itself can be placed on even in less than 1 year.
Yes.
If it is compulsory registrable, you cannot claim any right.
Yes.
All right. What is your point, Dilip?
Yeah. Regarding section in the introduction of subsection F, 1F, 17.1F.
Yes.
One second. 17.1F.
Yes. Instruments purporting or operating to effect a contract for sale.
Section 17.1 contained 5 instances of where the documents were declared to be compulsorily registrable. Then after F to K were added. F to K were added as compulsory registrable documents.
Correct.
And this explanation to 1A, said that even though a contract for sale was not compulsorily registrable, but for the purpose of availing the benefit under section 53A, it should be registered. That was the explanation.
Correct, absolutely. No, that is 1A. That is 1A.
1A. So that explanation was made redundant by this amendment, because all agreements for sale were also made compulsorily registrable. But there is no corresponding amendment to section 49.
Yes.
Which only speaks about the consequences of non-registration.
Yes. That is why we are relying on the proviso to 49 in cases covered by 17.1F.
Dilip, I perfectly agree with you, because by introduction of section 17.1F, now we confine to F because other clauses we are not discussing.
Yes.
F says that all contracts to assign property has to be compulsorily registrable.
That is agreement for sale, even agreement for sale.
Even agreement for sale. It has a direct impact on 1A, no doubt about it.
Yes. What I want to say is, see, section 49 encompasses the effect of non-registration of compulsory documents of all types. So an addition of, inclusion of contract for sale in section 17.1 also is subject to the proviso, because proviso is an exception to the consequence of non-registration of a compulsory document.
Dilip, I would like to present it in a different way, because section 54 of the TP Act says that an agreement to assign will not confer title.
Yes.
That is the fundamental law. So
Yes.
an agreement to assign property, you can't say that it creates, limits, declares, extinguishes title covering in section 17B.
Right.
It is only a contract.
Yes.
It remains a contract until it is performed.
Yes.
Okay. So it doesn't create, limit, or extinguish any right. It's only a contract. So
no
that
passing
is
of title. No passing of title. No passing of title.
There is no passing of title by execution of a contract.
Yes.
So originally, that is why the original act did not provide for a compulsory registration there.
Yes.
Then by virtue of this 1A, what is stated is that for a contract to assign, if it has to be received, it has to be considered for the benefit of 53A, it must be registered. So
yes.
Actually, that is a restriction imposed in the case of this thing, this contract for sale.
Yes.
Okay. Then, as you pointed out, 1F says that it has become compulsory registrable.
Yes.
Agreement to assign.
Yes.
So it can't be received in part performance thereafter.
Yes. Yes.
So it has a direct impact on 1A in Kerala.
Even every contract for sale should be registered.
We are speaking the situation in Kerala. Please understand, this is only in Kerala.
Yes, whether or not it is for 53A or what.
Correct. Now coming to proviso, now this can't be used as evidence of a contract means suit for specific performance. That is also not possible.
No,
if it is not registered.
My submission would be section 49. No document required by section 17 or any provision of the Transfer of Property Act 1882 to be registered shall. So, but after amendment of 2013, section 17 takes in F also.
Not only that, Hariprasad, I will have to go by the intention of the legislature for amending that provision, because probably it is for the purpose of protecting revenue of your
yes.
Or later coming with the stamp duty evasion. Probably that was the intention. Every agreement to sale will have to be registered.
But
probably the right arising out of for certain purposes, for specific performance, etc., will not be, because still the section 49 proviso will be doing it unless it is amended there also.
Okay, Dilip, 1 minute. Let me understand you correctly. You say that by virtue of section 17(1)(f), the proviso remains unaffected by that. Is that your case?
Unaffected by that, because section 17 incorporates or includes only another set of documents to be made compulsorily registrable, and the effect of non-registration is compiled in section 49.
49 first part.
First part, and the proviso is an exception to with regard to the contract for specific performance. I mean, the contract for sale. That remains unaffected.
That right will not go.
That right will not go.
Correct. That is one way of looking at it. Of course, I agree with you. That is one way of looking at it.
All compulsorily registrable documents covered by the main part of the proviso.
Suppose that proviso was also deleted by the amendment. Probably, as far as Kerala is concerned, that will hold good sometimes.
Yes.
Actually, I was viewing from one angle that this 17(1)(f) has an impact on the first limb of proviso. As Dilip points out, there is some logic in that. It may not have any impact on the proviso at all, because what is impacted by non-registration under section 17 is in respect to the substantive part of the section, not the proviso.
Not the proviso. Not the proviso.
That appears to be a good view. That appears to be a good view. I agree with you for that. Yes. You're right. That is a possible view. Anyway, we don't have a decision directly on that point.
Yes, we don't find it. We have not.
We don't have a decision. In fact, in my Ignatius case, that was not the point raised, and I could not. I had no occasion to answer that.
Arguing this point, I made a unregistered document. Contract for sale, I made admitted in evidence.
For collateral purpose. For collateral purpose.
No, as an agreement for sale. Because I wanted to, for a specific performance, I can use.
All right, there is some point. I agree with you. I fully agree with you, because anyway, based on Ignatius, probably I can't answer this, because Ignatius, this question was not raised.
That way, where the question was different also.
Correct. Anyway, there is a point.
How will you explain 1A? Dilip, how will you explain 1A?
1A has become redundant with this amendment.
1A has been directly impacted, no doubt about it.
1A is only for 53A.
No, that is in order to avoid that only, they made it a compulsorily registrable, not any purpose.
Yes.
The document containing contracts to transfer for consideration any immovable property for the purpose of Section 53A of the Transfer of Property Act shall be registered.
53A presupposes handing over of possession.
What performance?
Handing over of possession is followed by a claim for 53A.
Yes.
No, either handing over of possession by the document, or he must, if he's already in possession, he continues in possession. That is what 53A says.
The possession.
So that can't be decided now.
And he can use it only as a sword.
Yes.
As a shield,
As a
not
shield.
a sword. Not a sword.
By the latest judgment.
And a suit for injunction also can be treated as a shield.
But I think there is some point, because in Ignatius, I did not consider that this question. I think you are right. There is a point in this. Because proviso remains as it is, despite 17(1)(f). But 17(1)(f), I have no doubt 17(1)(f) has a direct impact on 1A.
Yeah, 1A.
1A.
1A is no more relevant in Kerala now.
Correct.
Sir?
Whether it is for 53A or for another purpose, every agreement has to be registered.
Correct. Right.
Yeah, unaffected by the last part of the proviso to 49.
Yes. Somebody is asking.
Yeah, Meenakshi, yes. Yeah, Meenakshi, please.
Sir, good evening, my lordships. I had a doubt. If a written document relating to family settlement, which is unregistered, also undisputed nearly more than 30 years, under possession of plaintiff, does plaintiff can benefit in a suit for redemption to prove the nature of possession?
Certainly. Please read that latest decision by Justice K.M. Joseph. That is now I just
2021.
2021.
It is in KSC only, but I do not know whether it come in the other.
It must have come in
the other cases also, because I saw in
Shyam,
KSC
can you please
only.
share the name of that case so that
Korukonda. Some Korukonda. Maybe from Andhra.
Chalpatra versus Samapurna.
Yes.
It must be from Brother Kodandram
case.
This is from Andhra Pradesh.
And you will get an answer to that.
Okay, sir. Thank you.
That decision directly covered by the Supreme Court recent decision. You will get the citation from Shyam, please.
This is it.
This is it. This. Korukonda Chalapati Rao versus Korukonda Annapurna Sampath. 1st October 2021, it was decided.
Probably you don't have, the other journals.
No, SEC it has come. I don't remember the.
Yeah, I mean, when I got it very fast, I just put it for today's program. I'll get the citation and I'll share it by K.M. Joseph, sir.
Yes. This is exactly a case of family settlement, and what purpose it can be used is clearly mentioned by the Supreme Court.
Okay, sir. Thank you.
Okay.
I think Radhakrishna Murthy, please go ahead. He's raised the hand and I think he's disappeared.
He's unmuted also.
I requested him to unmute. Radhakrishna Murthy, are you there? Okay. We'll do one thing now. One doubt. Kala Devi, okay. Meenakshi. Then I think we'll go to K. Rao, sir.
Good evening, everybody. Hariprasad, sir, excellent articulation, well said.
Thank you, sir.
The churning began, and I think the churning is still going on everyone's mind. I mean, this is something that will, even though this is an evening well spent, this will play on everybody's mind about registration of documents. And just as Dilip sir and everybody said, the intention of legislature was only the money part. It was not to protect anybody's interest. It was only to protect state. It was only to protect state interest, and nothing beyond that.
No, sir. Rao sir, I may add a word. The state is protecting your state is providing certainty for your transactions at the cost of money. That's all.
Yes, that's true. No, I agree, sir. I mean,
Rao sir, on the lighter vein, it is said that in law nothing is certain but the expenses, just like that.
True. I mean, that's true.
So when you engaging a lawyer, it is so.
Yeah. Like, when you pay for something, you want full ownership. You don't want any ambiguity. So that is one aspect.
But what about Muslim gifts? Not compulsorily registrable. Even an oral gift is valid.
Sir, I wouldn't want to go on to that now and get into deeper trouble. No, as I said, so it's an evening well spent, and as usual, we need to thank Shyam sir for giving us this beautiful platform. I mean, around 270 sessions is not a joke to keep it going, and getting excellent speakers. And when I say excellent speakers, it's not in terms of oratory terms, but in terms of trying to understand somebody's problems and assimilating it and giving a reply as well. So that is where everything is really important. And this platform does it absolutely well. And
Radha Shramati has come. You want, you can.
I was there, sir. I don't know.
I think the concluding remarks could be just kept in abeyance for 2 minutes. Okay, Radha Shramati, please.
Put pass for that.
Yeah. So that's the reason actually I called Shyam and all just now. Actually, I'm not able to unmute and all. So now I think he made it. So I'm sorry for that inconvenience and all. My question is actually, see, in an unregistered mortgage deed, okay, a financer has given finance and in which that there is an arbitration clause. So the time and again the Supreme Court has said, even if it is an unregistered, though the document is compulsorily registrable, but if it is unregistered and all, but still the arbitration clause will prevail. So by virtue of that and all, that they have already invoked the arbitration. But though that they have invoked the arbitration, this thing, now the arbitrator said, since it is not a compulsory, since it is a compulsory registrable document, since there is no registration, I cannot look into the other terms. Correct. So if it be the case, then what is the use of, now, because when I have invoked and all, so necessarily I have to, do my case before the arbitrator. I cannot go to the civil court, in which that there is a clause saying that the financer has to, insure the building, which he did not do so. So now that there is a damage to the building itself, therefore I need not make the payment. One of the clauses says I need not make the payment.
Good question.
There are two things in it. Before Hariprasad sir answers, number one is that it's just like saying that I paid court fee, I should be given a judgment. Number one. Number two is that arbitration agreement as defined under the Arbitration and Conciliation Act is a clause in an agreement which is a standalone clause. Just because that is valid, but then that will not validate.
For deciding the dispute in arbitration, you may have to refer to the terms of the document.
Then all the infirmities, all the issues of evidentiary value, etc., will again come in.
And the collateral issue.
I know pretty well that the document is not registered. That is the reason I went to the civil court. Civil court that they took an objection saying that there is an arbitration clause. Therefore, as per section 8 and all, the civil court does not have any jurisdiction. So therefore, I was forced to go before the arbitrator. Okay, arbitrator has been appointed and all. But thereafter, whatever clauses are there in that and all, when I wanted to take, stand on that, it has become difficult for me.
It's very natural.
Arbitrator not being a court, probably these restrictions may not apply.
Mr. Adashmurthy, may I seek one clarification from you?
Yes, sir.
Are you the mortgager or the mortgagee?
See, my property has been mortgaged, okay?
So you are the mortgagee.
Mortgager.
You are the mortgagee and you are the borrower from the company also. Insurance.
Yes,
what is this?
Exactly, finance company.
You have borrowed money from the finance company.
Yes, I have deposited my title deeds. And that title deeds and all, as per the law and all, which is supposed to be registered,
no, not
registered.
One minute, please. 1 minute. No, if it is a deposit of mortgage created by deposit of title deeds,
no registration is necessary.
Equitable.
No registration is required.
Equitable mortgage.
If you execute a memorandum of deposit of title deed subsequent to the transaction,
it should be a notified area. That's all.
No, it must be in a notified area. And it must be deposited with an intention to create a mortgage. Yes. And if the deposit is made and a mortgage is created, and you execute a memorandum of this deposit of title deed,
it is there. That document is there.
Subsequent to the mortgage, then it need not be registered.
No, because in that the position is taken. That's the reason.
Oh, then usufructuary.
Probably I think it was by virtue of the document only the mortgage was created. Probably.
Yes.
And possession is given. And dimension possession is given.
Ramkumar sir, we'll simplify the entire issue. Radhakrishna Murthy's case is a case wherein the document is compulsorily registrable. We'll take it like that. Let's forget about the nature of the this thing. And it is not registered. But there was an arbitration clause. His grievance is that the arbitration clause was invoked by the rest of the document is not being relied upon. Very natural. I don't think there is an infirmity in that.
No, for deciding the dispute covered by the arbitration, he may have to necessarily refer to that document.
No, then that document which is compulsorily registrable has not been registered. Then all the other attendant problems regarding that will arise.
Sir Ramkumar sir, the question of arbitration clause only decides forum.
That's all.
All other legal issues will have to be on the basis.
But then it is not a civil court.
No,
will not these restrictions apply to a civil court only?
No, I beg to differ, except the fact that the arbitrator cannot decide whether there is a mortgage or not, which is prohibited by the non-registration. He can look into other aspects without finding whether there is a mortgage or not, because you can't rely on this document as a mortgage transaction. But for other purposes, collateral purposes, it can be used. That is
sir, then the question arises that they were supposed to insure my premises, which they didn't. Now the property is lost and they are not paying, and they have defaulted. That is
the term of the document.
That's completely independent of the mortgage transaction. You need not establish that there is a mortgage to enforce a contract that a person should insure it, because it's an independent transaction.
Correct. That is another way of looking at it.
That is why I told you.
You're right.
That is why I told you that if it is divisible from the main transaction, and if the second transaction is not a compulsorily registrable thing, then it can be used as a collateral purpose.
Yes.
Radhakrishna Murthy, the final thing is that
not that any right arising out of such a contract. If it is compulsory legislation, will it be possible to be
any right to the primary transaction? Primary transaction is mortgage. We are not dealing with that. There is an independent promise to insure my premises, which they have failed and neglected. Are they not liable?
And if that is separable from the main transaction,
that is divisible.
It does not require a registration.
Divisible clause.
Then they will have to go by your section 91 and 92. But 91, 92 is there, then a document is there.
And no, 91, 92 will not come because it's already
registered in writing. If you want to
stand of the arbitrator may not be correct.
If you want to enforce a right arising out of a contract, which is compulsorily registrable.
I mean, had that transaction of offering to insure and failure to insure, if that was that promise
if that be the case, an unregistered lease, I can claim rent.
Rent you may, but not enhancement of rent provided.
Not rent, use and occupation.
Payment
for use and occupation.
That is a different word that has been used because you will become an unauthorized occupant.
It is legally valid.
You're in adverse possession
for use and occupation.
You are putting a different name than rent.
Not between human beings.
Correct, sir. So, sir, we are fringing 7 o'clock. So, Radhakrishna Murthy, 10% of the fee is to be paid to the company. Okay. So, over to you, Rao, sir, for the concluding.
Yes, sir. Like I had said mostly what I have said, sir. I really thank Hariprasad, sir, for giving us his time and coming here and explaining things to us. And I thank you once again. Over to you, Shyam, sir. I've said most of what I have said, sir.
Thank you, sir. Thank you, sir.
Sir, as we come to the end of today's session, tomorrow, I would say, would be a continuation of today's, in the sense like tomorrow we are dealing with a very interesting subject, which is closely related with today's subject, that is rules of evidence and courtroom practices in receiving oral and documentary evidence. The speaker, sir, 10:30, sir. The speaker is Justice.
I will not be there.
Sir, okay.
10:30.
Unavoidable function to.
But the speaker, of course, is Sir Justice M. Sitarama Murthy, sir. He is currently chairperson.
We are having him after so many.
So many
sessions.
He gave the date and time, so I was not able to change it. He's the
really
chairperson currently of
I've been
Andhra Pradesh State Human Rights Commission. And the introductory remarks is by our Justice K. Abraham Matthews, sir, who is currently the chairman of Kerala State Farmers Debt Relief Commission and former director of Kerala Judicial Academy. So once again, thank you very much, Justice Hariprasad, sir. Thank you, Justice Shyam, sir.
Thank you to everyone. Good night to everyone.
Shyam, can you send me the video tomorrow itself?
Yeah, I'll try, sir. I mean, that is, I'm a bit technologically challenged, but still I'll try my level best, sir. So Ramshan sir, Kondaram sir, Rao sir, and all of Dilip sir, all of you wonderful participants, and especially the students of Bhavan's Pulsar Law College for being here. And the homework for you, I'm sure that your faculty also would be listening, is to have an in-depth analysis of what you heard today and a critical evaluation, your own thoughts, because the law has to develop through the hands of you social engineers. So till we meet again tomorrow, 10:30, please do take care and stay safe. Thank you.
Thank you. Good night to everyone.
Good night.
Thank you.